we all know this, that for a lot of people, a deposition or testifying at trial is, one of the more terrifying things that people do. And so we're taking people and putting them in a high stress situation, and it's a setup that isn't necessarily conducive to making people feel comfortable. And so one of the things that I know, this, and I just since we're running on time, I think Erin deserves so much credit for that. This is a topic that she has been really championing, and I know that this was something that was really important for her to think about, is doing more in court to accommodate people who are neurodivergent in those situations.
Judge? Yes. Okay, so you brought up a really good point. If you have a witness that you know is key, and I'd like to, of course, this is what we do, we judge these witnesses, credibility, and you know this is going to create, this kind of issue in court. How do you deal with that with the court without crossing the line with HIPAA and opposing counsel? How do you deal with that?
I think that in some instances, people are going to be comfortable self-disclosing, and so you would get around that because you might ask them on the record, and then they could explain that.
That would be you. Wouldn't be the court because the court wouldn't know.
Yeah, no. I'm saying the counsel that's putting on the witness. So if I'm putting on a witness and I'm worried that something about their demeanor might impact credibility, and they're comfortable talking about it, you might ask them on the record about that, and
Okay, and so opposing counsel wants to take them on board on now, and you're going to get into a real fine line there. And then what do you need to disclose to the court to permit that to happen or shut it down?
Well, and I guess procedurally, the one thing, if I've got a client who would not want it to disclose, I guess publicly, is maybe ask to do something under seal, and we at least try to protect the disclosure that way. But then, at the end of the day, the other party gets a chance to cross-examine, take on more dire, and we have to,
But I think to your larger point that it really is something where what we're talking about mostly is trying to be more cognizant of it yourself, so that you can best work with the person on how to put them in a situation where whatever that behavior is that may be impacting credibility is more managed. So like the example I gave of if I'm standing up and I would be moving around a lot, if they have any sort of things they can do like that might help control it.
Sure, and as a court, we're going to accommodate parties and witnesses. And a good example is, I get a lot of pro se litigants that speak only Spanish. We don't have any court records, so I talk to them in Spanish. But we make an English record, but you need to make them comfortable so they can talk to you and walk them through the process. So this is sort of like that. It's a little bit different, and so this is something new to me, and this could, create a problem for parties, witnesses that shouldn't impact the proceedings, and that's my main concern. How do we as a court, and how do counsel deal with those types of issues, so that everybody's aware of what's happening and not being, like I said, the client or the witness for this particular issue that we're going to be dealing with here, because it could. There's some witnesses that just won't look at you, or they'll look up or they'll look away when you're asking questions. Well, when I ask them a question, they don't look at me. It tells me a lot, especially the kind of questions I ask. So I pose a question, and there may not be a right answer, but I think just to raise a little awareness of maybe how that could be brought up to a court would be something I'd like to know about.
Yeah, absolutely. And I think that it's something that people are like, there seems to be a big movement on research into this area of how to both accommodate and how to deal with these issues when they come up. So like that ABA paper from 2023, I know there's more stuff in that area. I think that where we're at right now is I think the things that are probably more situational. So things like bright lights and crowds of people and things like that. Courts are very good at accommodating that when an attorney can explain that that's an issue for a witness. The things that are sort of more behavioral, I think, present a lot thornier challenge, because if it's your witness and you're concerned about that, it's pretty hard to navigate if there aren't things you can do that, deal with that on the front end.
Thank you.
Thank you, Judge. And with that, I think we're out of time. Thank you all very much.
All right, colleagues, we're on a 15-minute break before our last two sessions.